approach to crossover. So we've assembled folks from various disciplines. We've got judges and public defenders and county attorney, and also Steve on behalf of the Dodge team, to really explore some of the strategies that are taking place across the counties with respect to, in my mind, two really critical themes of the crossover work. And the first is when you think about the decisions that have to be made in the system throughout the entire process that affect young people and families. We think about the decision to divert or to charge, the decision around detention, the decision around adjudication and disposition. One of the key elements of the crossover work is how do we ensure that the information that we're receiving to inform those decisions is rich, is complete, is of high quality. And so really what we've focused on as part of this work over the years is developing those structures and those strategies in place to make sure that the decision makers really have the full context of a young person's life and the life of the family in order to make those important decisions. The second sort of key theme in my mind as I think about the topic that we're about to discuss is how young people and families experience our systems and experience the way that we interact with them. And we've done a lot of thinking throughout the crossover work about how do we shape our approaches and our environments and our relationships with young people and families so that they feel that this is truly a collaborative effort. So as part of this discussion, what I'd like to lift up, and I'll be leaning on you all in the audience as well, is what are some of those strategies around some of those two key themes, around that really important information piece and that richness of information. How do we go about informing the decisions that we have to make? But then also, how do we shape the experiences for young people and families who do touch our systems in a way that is positive, that is strength-based, that is designed to really achieve positive outcomes? And in my mind, why this is so important is because those decisions, if you're not making them in line with what the research shows is effective, then we're likely to set up young people not to succeed in the long run. The relationship piece between young people and families that we've been talking about all morning, if we look at the research around procedural due process and this notion of fairness and how young people and families perceive our systems and the importance that they see it as a fair process that really allows them to share their voice, that has a direct correlation with how engaged they are with us as system professionals, as system officials. And so if we're not being thoughtful about shaping those approaches in that family-centered way, then we're setting ourselves up for long-term failure. So all of these strategies really are designed with that ultimate end goal in sight, right, of improving positive outcomes for kids, for families, but also for your own staff and for communities. So that's the general framework for how we're approaching this conversation today. And I want to open it up. And again, the first panel really focused on the front end of the system. We talked a lot about diversion. We talked about how we orient families to the system. Now we're going to begin to talk about some of the decisions that we make, particularly as the young people and the families proceed down the court process. So I want to start with a broad question for the panel. I'm going to move over here so I don't have my back to these folks. And I want to just ask you just generally, very, very broad question. Since you have launched the crossover youth practice model in your jurisdiction, what would you say is the most significant change that you have seen? And feel free to answer it in any way that you'd like, but I want to start intentionally very broadly. What is the most significant change that you've seen as a result of this process? And I don't know if we've got a first one here.
In Sarpy County, I think, at least from the public defenders perspective, it's the information sharing. It's not just with, we've always gotten the information from probation that we've needed, but it's getting the information from NFC and knowing what's going on the 3A case. There's just more information readily accessible so that we know what's going on that case, because it directly impacts what we're doing on our case and the delinquency side.
I sort of have 2 points that I would make on that, since Lancaster County has started. Not only is it the information, but we have the right people at the table. Many times we would have an HHS worker show up for a detention hearing or adjudication or disposition, but it may not be the worker who's familiar with that youth, that juvenile, and the family. And so now we generally have the actual assigned worker, or we have the supervisor. So somebody who really has the knowledge about that if there are questions. So I think that that's been a positive change. The second thing is more on the other side of the court case when you get to disposition. I went around and talked to the attorneys in the office to get input for them and to be able to come here to talk today. And the one thing that was pretty consistent is they felt that with the better communication and information coming in, that the judges were putting the juvenile on shorter probation terms, or probation orders that were not just, let's throw every term possible in. And I think that was because they felt comfortable with HHS involved and everybody on the same page, that they could get services through the HHS side as well, so they didn't have to throw everything into a probation order. So the result being for our clients, hopefully shorter probation terms with terms that the juvenile gets more easily as needed.
Steve?
Comments here, but also that it seems like the services are being nowadays a little quicker with evaluations being made, so they're just making that ruling, especially with the kids that remain in detention, just making sure that the referral gets made right away, and the operators collaborating with the HHS worker and making sure getting that evaluated in the detention facility.
Steve, put the mic a little closer to you. Ron, even?
Which means I'm loud.
Did you get all that?
I'm afraid to talk into it.
Somebody has an athletic personality.
I need a new battery.
Can you guys hear me? No?
We might need a new battery.
I can just talk loud. Can you guys hear me?
There you go, Kara.
Yeah. I probably don't need the mic anyway.
Is it not working?
I don't think so.
We're gonna.
Maybe the battery went out.
I think I can do okay without it.
Okay.
I agree too with what everybody said before, the information sharing, true collaboration between the agencies in Douglas County and the legal parties. And also, I think probably our most significant change would be fewer system-involved youth. The way that we do it, we have our crossover team meeting before that filing, that charging decision is made. So it's at that time that we can decide to divert them from the system altogether, not even to file on the case. So I think that those kind of outcomes have been a big change.
Well, I touched upon this before, but I do think one of the big changes is sort of the institutionalization of the relationships that already existed. And I think that's important, one, because there still continues to be a fair amount of change in NFC and workers and supervisors. And so having sort of a set way of doing things and a set way of collaboration, I think is going to be helpful over a period of time. And I think that's been very helpful. The other thing that I think has been helpful, we haven't had a lot of cases yet. And at least the ones in my court have been ones that we have dealt with in our system for a significant period of time, in which there's significant dysfunction both in the family and with the juvenile. And we're sometimes at our wit's end about what do we do next? How do we make these, how do we make sure there's going to be change within this family and with this juvenile? And I think that joint planning has been really helpful in helping us see a way forward into how we might proceed with a particularly difficult situation in family and kids.
I just have two quick things. Typically in our county, we do detention hearings at 8:30, and on 3As are 8:45, and the pre-hearing conferences are 8:15. But we made a conscious decision to have these staffings at 1, so that we'd get more folks there and have the hearings at 2, which means sometimes we have to move another hearing. But the result has been that we've had a lot greater participation, I think. And the other thing is we've encouraged people to speak up. You're not going to be punished for having an opinion. And I think through this process it's helped inspire some folks who may be silent, particularly parents, to speak up. And the third thing I'll mention is I've not had one disputed crossover hearing. Sometimes we can handle them by stipulation and get that kid back to school. So I really have nothing, and I really have nothing but high praise for the people that are involved in this process. Probation, NFC, other support staff, they've been great.
So I want to probe, one of the themes that I'm hearing about is the improved quality of the information that we're getting. Dennis, you started off by talking about some of the information sharing, and then both judges, I think the pre-detention hearing process that you've set up really allows some of that initial information to be shared. Let's talk a little bit about how you're approaching this in a systematic way, some of the structures that you've put in place to get that really good, rich information that can inform your decisions around charging, or your decisions around detention, your decisions around disposition. So, Kara, I'm going to start with you. If you could just say a little bit more about how you all are approaching this in your county, about how you're making this decision around diversion versus filing, and the type of information that you're seeing, and what, from your perspective, what is some of the most useful type of information that comes out as part of that process?
Okay. In Douglas County, the family truly is involved from the beginning. Like Tim talked about making the phone call, as soon as the youth is identified crossover, so they have an open 3A or a non-court case, so they're eligible for aftercare, and then they pick up either a law violation or a truancy citation, then we'll invite them in to have a team meeting with us. No charging decision has been made at all. It's at that team meeting that we decide how to proceed with the charge. And the youth and the parent or the foster parent, whichever guardian comes in, they are made a part of that team, and we all make the decision together. So it's the county attorney and someone from the JAC, someone from probation, someone from NFC, someone from HHS. Oftentimes we'll have a therapist or a school person or anyone who's willing to come in and advocate for that child. And then it's at the meeting that we make the charging decision. So it's in real time that we're getting information from all of those people, and all of those people who have had access to the youth and any sort of communication with them, they can come in and be a part of that meeting, and then we're able to communicate with each other. I always explain that we have 4 different options that we could decide to proceed on that charge. The first one is where we nolle pros it or no charge it, and I'll explain to them that usually we'll use that option if the situation's already been resolved, if there's really nothing else for us to do, depending on what's going on in their life or what the circumstances of the charge were. The second one we call nolle pros enhanced, where we still nolle pros or we no charge the referral, but we're able to enhance the services that they have. So if they're in need of something that they're not getting through the 3A case, or sometimes they'll want a mentor, or sometimes they ask for therapy or whatever, we find that they're lacking, and we can hook them up with services. And the third option is diversion. And it's at that time, as a team, we would come up with a diversion plan, and that youth would be expected to follow the diversion plan, and it would be similar then to like a non-crossover diversion, where they would be set 3 months or 4 months or whatever on diversion, and if they completed it, we would successfully complete them, charge goes away. If not, we would look at that and see if they needed to be filed on. And then the fourth option is to file in court right away. It's very rare that we actually file from a team meeting. I think maybe once or twice we've made that choice since I've been there. So at that initial meeting, it's when we do make the charging decision, the youth and the parents are a part of that. And I think from the beginning, we, and it's evolved too, but I think we've realized as a team, it makes a huge difference, the attitude in that room, if we come from a helping place as opposed to, you know, I don't need to flaunt my power, and nobody else does. I think it's pretty obvious that that's why they're there. So once they come in the room, we'll tell them, you're not gonna go to jail, we're not gonna remove you from your home, I'm not gonna use anything you say against you, you can talk freely, we're here to help you, we wanna know what you need.
So the amount of resources and energy and effort that it takes to convene this teaming in advance of the decision is considerable, right? I mean, it's a remarkable thing that you're doing. This is not something that's happening, you know, in every crossover jurisdiction. In fact, you are, in many ways, leaders in this respect. How do you, you know, you think about the process and you justify all of that time and energy and effort that's going into this? How do you justify that? How do you, what are some of the benefits that you've seen since moving to this approach, as opposed to just relying on, you know, say, paper, or perhaps a phone call? You know, what do you see as the value of convening this meeting that perhaps wasn't happening, you know, before you introduced this?
I think one of the things, we've talked about trust for most of the day, and getting the same group of people in the room every Thursday, because we meet every Thursday for 3 or 4 hours, and it's generally the same people unless someone needs a backup for whatever reason, does make a difference because we do have that trust there. I have a particular role, everybody has their own role and their own interests, but I think we've learned that my interest is not the most important, you know, or Darcy's isn't, or Dan's isn't. We have to truly collaborate and look at the best interests of the youth who's there, and we're able to do that because we do all trust each other. Like I said before too, we haven't had to file as many cases. We haven't had to file as many juvenile justice cases because we have this process. So when you look at resources and money and everything that's spent in those, you know, the court cases themselves, we've gotten away from that a little bit. So we've had a lot of good outcomes for youth.
Do you find that the nature of the information that you get through this process might be a little different than, you know, perhaps a process that relies on paper or from?
Absolutely.
And just say a little bit more about the nature and the quality of the information that you get.
I like to think we make good decisions even if we're only going off the police report, because we do have to do that too. But for these crossover cases, I think it's invaluable having team members there. I think, you know, whether it's a school person or a therapist or a caseworker or a probation officer who can share information that they have that we might not be able to get on paper or from the computer system. Most importantly, it's having the youth there, not just what he or she is saying, but body language. We can see the relationship between that person and the parent. We can see just the relationships in the room. We can tell so much just by how the child responds to our questions. And again, we try our best to make that person comfortable, and I feel like we do a pretty good job of kind of fostering honesty in that room, and we've, I think, all been surprised really about how honest some of these kids are with us, and the more information the better. So we absolutely can target our, you know, interventions to what their risks and needs are.
Well, like I said, I mean, I think this is very much a unique approach and an important one that you're taking. For other folks in the room, are there any questions for Kara in particular as we think about this teaming that takes place before the charging decision? Before I move on to the next decision point, which is around detention. But any other observations? Yeah.
Well, I sat in on the Douglas County one, but I just kind of had a question that I didn't ask you before I chatted with you. Is how you kind of decide who asks what questions of the youth? Do you kind of just go situation by situation, or does one person ask certain questions? Definitely
situation by situation. We have a script, but it's, honestly, I don't remember what my part of the script says. Aside from my spiel about the 4 options when I talk about no lay crossing or charging in court. Mandy is our wonderful facilitator, and she usually introduces herself, gives a little bit of information about the process, has us all go around the room and introduce ourselves, and then she kicks it over to me, and I explain about the 4 options, and I try to make them comfortable. I'm not going to use anything against you. Kind of explain why we're there. And then Mandy, as the facilitator, starts asking the questions. But we all jump in when we have questions. Sometimes I ask a lot of questions, sometimes I don't. Sometimes, Sarah will ask questions, and she does so much work with the schools that when it's school related, we generally look to her. I think we've worked together so much. I feel like I can read Mandy's mind sometimes, and that she knows what I'm thinking or going to say. And I think that relationship is very helpful with all of us because we know each other well enough to kind of know where each other is going to go. But we don't have, I'm not asking these particular questions every time.
What are the discussions surrounding the charge like? What does that look like?
We usually, and again, Mandy usually leads this. I've kind of set it up by saying, we're not going to use anything against you. We have a copy of the police report. We know what it says. We want to hear your side of things too and kind of what was happening that day. And then Mandy will ask them, okay, we want to know what was going on. Just kind of walk us through the day, what was happening. I don't need an admission necessarily. We don't need them to say, I did this and this and this and this. We're not looking for, extreme detail about the particular charge. I think we've had maybe 1 or 2 times where it's been disputed, and we deal with it. Usually we're able to come to some sort of a consensus. And it's interesting too, I don't know if it was Shay before saying, talking about hopefully that the youth is going to buy into whatever it's a team effort as far as the decision making. And we've been lucky enough where usually it is. It's like a living organism in that room as we're making decisions and brainstorming and bouncing things off of each other. And we don't go in there with a formalized opinion as far as what's going to happen. We're literally kind of changing our minds and able to adapt to what information we're hearing and go from there. And even the kids that we put on diversion agree with being put on diversion. So I don't think I've ever had to say, you're going to go on diversion or you're going to court, deal with it. They're willing to do it. They agree to do it and to accept responsibility and to follow the recommendations that we've given them.
So I want to probe if there's other questions on this. And Kara, I'm going to come back to you in a minute as we talk about the relationship between prosecutors and public defenders in your jurisdiction. I want to probe a little bit specifically about this process and how public defenders have reacted to this process. But before I do that, I want to talk about detention. And the judges mentioned in SARB this, I think, very smart, thoughtful way of maximizing resources and lessening the burden on youth and families around trying to come to some common understanding in advance of that detention hearing so that folks could come in with some recommendations to the court when they're before the judge during the hearing. So Dennis, I'm going to start with you. Can you share a little bit, you've participated in these meetings. Can you share a little bit about your observations about how these are going, why you think, if you do think they're a good idea, why, and whether this is an approach that other counties, either here in the room, represented in the room, or perhaps as we move this out statewide, if this is something that they should be considering.
I have.
Dennis, would you mind grabbing the mic when the air conditioner kicks on? It's really hard here. We've got it fixed, I think.
I think so.
I think it's on. There you go.
It's on. I do think it's a good idea. I think back to the last detention hearing we had with the crossover youth. It went exceptionally well. It gave the youth an opportunity to really set forth what her thoughts were and some of the things that she thought was helpful, those things that she didn't think was helpful. She'd had a history of out-of-home placements and various services for several years. And everybody had everybody's opinion was able to be heard, but most of all hers. And we really, with the help of the professionals, really worked through the ultimate solution, which we came up with at the detention hearing. And she's doing really well today, and ever since that detention hearing. So I would highly recommend it.
And I don't know if you've got more to say there, but I do want to get the impressions of Judge O'Neill and Judge Gedler I mean, I know this is a relatively new practice, but from your perspective, what is that conversation looking like at the detention hearing? Now that you have this meeting taking place, are you seeing that sort of consistency around the recommendations, that the parties truly are coming together and saying, we jointly agree that this is the way to go? What about the richness and the quality of the information that we're getting? But say a little bit from your perspective, how you're seeing this.
I do think we're getting better information and more complete information. I think we're also getting, probation and the department or NFC have different strengths and different abilities. We're also getting how we're going to sort of parcel out some of the services and things that we're doing to the appropriate agency, and the agency that's most likely to be able to deliver on what we want to have done. And I think that's been really helpful. I agree with Dennis. If Dennis and I are thinking about the same young woman, and I think we are, that her level of buy-in, this is a young woman who has been very defiant at various court hearings and always talking about what other people are going to do to her. And I do think in this last round of the detention hearings, she had a level of buy-in, and she had an understanding that even if she couldn't get what she wanted right at the moment, that there was a pathway to get her to where we wanted her to be. And that was really helpful, because this is a young person who has been on the run a number of occasions, and gets frustrated with things that are happening, and then her response is to take off. I think she saw a pathway forward, and that has helped keep her safe, and I think that's been really important. So,
Well, again, like everybody else, my experience has been very positive. I think we have to remember sometimes that some of this stuff is episodic. These episodes really don't define who they are. They made a mistake, they made an error in decision making, and how are they going to learn from it, and how do we enhance that prospect? And as I've said, I've not had one contested hearing yet. The other thing I try and do is explain to the parents and the child who's going to be doing what. Because there's two files there, there's two agencies there, and they're not going to understand that process. So I'll literally hold up each file and say, here, this is the file that deals with this issue, this is the file that deals with this issue, this is the person that's going to be arranging the tracker services, this is the person that's going to be arranging the therapy. And then when I'm done, I want to make sure they understand who's doing what. And then I want them to call their lawyers if these things don't get arranged. And they seem to have a little bit more clarity with that effort, I guess.
I think, we were talking earlier about this differential of power between system officials and young people and families. And what you're describing really are efforts designed to make it more of an environment, right, where young people and the families get the message that this is a team effort, that we're listening to you, that we hear you. We're trying to relay the information in a way that's understandable. In my mind, these are efforts that really break down that differential, whether it's perceived or actual. What are some other things, Judge Gendler, Judge O'Neill, other strategies? And then I'm going to turn to Steve to hear a little bit about how Judge Van Pola approaches this in Dodge. But from the judicial perspective, when you think about creating that atmosphere that is really directed to try to build some of that trust and have that open line of communications, what are some other things that you are doing? Say for a young person who appears before you for that initial hearing, that detention hearing, and then throughout the process, how can you shape that court environment in a way that really is that family-centered and strength-based?
Well, I don't know. I will tell people if we need a hearing next week, we'll have a hearing next week. And I want people to maintain contact with their lawyers and the professionals. And if there's something wrong, we can bring that case back right away. I don't want people to think when they leave the courtroom that they can't come back for months. These issues have to linger. So I hope that helps.
Yeah. That's good. Judge O'Neill?
When I think about any of the initiatives that we're utilizing in juvenile court these days, whether it's problem-solving courts, whether it's the use of things like pre-hearing conferences in protective custody hearings, all of them sort of center around having that person, whether it's the adult or the young person, have a sense that they have a stake in this and they have a voice. And so I would just say that in our limited experience, it's that voice piece that I think at least bodes relatively well for the proposition that they're going to follow through and do the things that they need to do. I agree with Judge Gendler that it's then incumbent upon the people, the adults in the system and the professionals in the system, to provide that follow through so things really do get done, because we've bannered around the word trust a lot. That's where you lose trust, when they are told that certain things are going to happen and they don't happen. And so, or they don't happen very rapidly, and we've got a voucher issue, or we haven't got the evaluation back from whomever. All of those things are detrimental to creating and keeping that trust that you have done a pretty good job of fostering at the beginning with the processes that we're undergoing. So,
I couldn't agree more. We heard earlier about the process in Douglas, the follow through from Kara in your office, that if the recommendation that is made at the meeting, we know that there's going to be follow through. There's going to be that follow up. So I think that really is an important element. Steve, I would like to, Shay and I had the opportunity throughout this process to sit in one of the court hearings, if we can call it that in Dodge County. Can you describe for the group what this looks like, what the environment of the courtroom that Judge Van Pola has designed? My understanding is that this is something that he does across the board for all cases, not just crossover. But given the needs of crossover youth in particular, this approach seems to be very valuable. Can you share a little bit about what that looks like? What is the courtroom? How's it set up? What is the type of interaction that happens there?
Sure. I remember years ago, Judge Van Pola would be up on the bench, and maybe the youth would do something positive, and Judge would come around from behind the bench, walk down there, and shake the youth's hand, or something to that effect, depending on what was going on. I think that eventually led to Judge's idea of rearranging the courtroom altogether. So right now he has a big table in the courtroom, and everybody sits around that table, and he describes it as everyone's being at the same level. Usually it's the long tables sitting this way, and the youth will sit right across from the judge. And the other stakeholders are around the table, of course. And Judge will talk to the youth about, this robe can't make you do anything. I have no power that way. I can order something to keep you safe, something to that effect, but I can't make you do anything. That's one of the first things he explains to the youth, just so that the youth really understands that, his actions are up to him.
I think it's exactly what Judge O'Neill was touching on, is this notion that really amplifying the youth voice in an environment that makes them feel comfortable. The story that Shay shared earlier about from Sacramento with that staff person who was describing the very emotional way, this breakthrough moment that she had with a very challenging young person, was this question that she asked really for the first time in the case, which made all the difference for how the relationship between the young person and the system officials went. And it was simply this: it was, what do you want? Right? That's what she described as really was like the watershed moment, was through all of the noise and all of the different information that's out there through this process, ultimately sitting down the young person and asking, what do you want and how can we help you get there? That simple question made a difference and really led to a different dynamic between the young person and the staff. But that's what I'm hearing you all describe, is setting up structures in place where we really can amplify the youth voice. And again, a lot of that requires good facilitation and that strength-based approach to the way that we formulate an agenda, or how we talk to and communicate with young people and families. A lot of you all around this room are doing this well. Jane, I don't know if you have thoughts on this. I know this is a big part of what you do as well. Let me
I think that one of the things that everybody else has kind of touched on, but that we always do is, and then part of it is when we do our meetings and talk about, is we invite the youth to make a decision. And we offer this as an opportunity where they have free will. If they choose not to do the diversion program, that's their choice. And we invite them to, they can pick to go through probation in the general court system and to think about that. And when our probation representative is at these meetings, we have them talk about that and what that looks like and what that would mean to them, and ask them if they have friends who've been through it so they can, relate to that. And then we talk about the program and what those opportunities are, and let them literally read their statement that they bring to talk about that. And then, again, empowering them to say, what do you need to be successful? And I think that really helps. And some surprising things do come out a lot of times that you hadn't even thought of, that they will raise up that what they really need or where they need help. And as someone said, maybe it's just a mentor. Someone, because they don't have any positive role models in their life, and that can make such a difference to them. So I don't know if that's, probably everybody's doing that in some form or another. I think it's just the words, and different kids hear different things.
Anybody else want to share thoughts on this point before I move on? Yes, Judge.
Quickly, I don't need that.
Okay.
I'm sure a lot of you do this too, but I will ask, what are you doing for fun? I mean, these kids oftentimes don't have too much fun in their life, and I think it's our responsibility to make sure that that happens too. So I will frequently ask that question.
It's a slightly different context, but when I was working in the District of Columbia, one of the things that we wanted to restructure was our equivalent of probation headquarters or probation offices, making it a place that young people wanted to be at, and so introducing some of those fun things to do. So we introduced a music studio and a place to do art, and a place where they could learn culinary skills. And so it wasn't just another office building, but actually a place that they wanted to be because there were some fun things to do. But thinking about how we can do that across the board, I think really becomes important. So I wanted to transition a little bit to some of the other meeting structures that you have in place to inform the disposition decision. I think most systems here, or most counties here, really rely on PDIs and some of those reports that inform the dispositional decision. I'd love to hear a little bit about how the disposition decision is being informed in your counties and some of the meeting structures that you've put in place to support that. I think in Sarpy is primarily the 1184 meetings that lead at least the beginning of that discussion and go forward. But for folks from Sarpy, do you want to share a little bit about how you're approaching informing the ultimate disposition? Either Dennis or the judges, or Sandra, whoever else wants to jump in. No, Judge?
No, okay. Wow, give that to somebody who's there.
Okay.
Well, at least from the public defender perspective, we do really three things. First, we want to talk to the youth during the process to kind of see what they want, to see what kind of outcomes they foresee, make sure they understand the process, the respective roles of the parties, a lot of that stuff. And then we have to do not just a lot of talking, but a lot of listening. And the third thing we do is we do an extensive record review. So we're going to want to look at the 3A file. We're going to want to look at those exhibits. We're going to want to look at the case plans. And sometimes we're talking 24, 28 exhibits before we get involved. We want to look at evaluations. We want to talk to IFP workers, trackers. We want to talk to caregivers. And we want to have a really good history because we can't know how to go forward until, at least from our perspective, we know what road they've traveled, what services they've had, the number of placements that they've had, the types of placements that they've had. And then we look for gaps and where they're making recommendations. on what we think, try to form a vision and then make recommendations based on that.
Margene, I'm going to come to you in just a second to get your observations on some of the relationships between parties in Lancaster, but I want to bring in either Amy or Lori here to talk about, in Lancaster, this question of getting ready for disposition and putting the information together in a report that can be useful to the judges. How are you all approaching that process in terms of the PDI development or other strategies that you've got going?
I think we have an advantage because we have one probation officer that does the PDI for all crossover youth. And she used to work for the department, so she really knows the ins and outs and knows the lingo and the abbreviations for things. So she really knows what to ask for. But once a youth is adjudicated and they're a crossover youth, the release will go to the judge, and once that's signed, then we then start sharing information with each other. We also will send them a copy of the PDI when it's completed so they can see. But prior to that, we have the caseworker be a part of that interview. And then prior to the recommendations going to the judge, she sends those recommendations to the caseworker, and the caseworker will then say, oh, I think it should be this, or I think we need to change this. So really collaborating together on what those recommendations should be. And we've even had caseworkers come back and tell us, I think you need to add this, and it really has made sense, where we were like, oh yeah, that's great information. So I think that is one area that goes really well in our district.
Thank you. I think, yeah, Judge.
I just briefly, in addition to all the reports that we get a lot of reports. Kids will write letters, which I like. Sometimes they're more comfortable reading them in court. Sometimes they prefer that we just take them as an exhibit. But we get a lot of these Dear Judge letters. And they can be, a lot of them are incredibly well written and fairly insightful.
That's wonderful. So I want to, I see that our time is quickly evaporating here. I want to turn to Margene here. I want to ask this question. You know, we've been talking a lot about trust and relationship building. As an attorney for young people, how do you message what is happening as part of the crossover work? In some respects, this might require a leap of faith on the part of young people and families, right? When we're suggesting that the way to move forward is by collaborating with all of these, system officials. So how do you, as an attorney, and I'm going to have the same question for Dennis, but how do you all message this generally to your clients about what we're trying to achieve as part of this crossover work in a way that really leads to that buy-in?
First of all, I would indicate that probably most of my clients, by the time I get them in the juvenile justice system, it's usually because they've already been adjudicated, may have a history on the child welfare side. And so they have some familiarity with that. And interestingly, I was talking with Amy about this earlier today, is that I sometimes feel that these clients are the hardest that I have to work with, because the other clients I can, typically are at home, or if they're placed in a group home, I can tell them, you just need to do what you need to do to get back home. Follow that probation order, work that program, get back home. You can get off probation by following your probation order. This clientele I've always found the most difficult to work with, because you really have to be able to be honest with them and say, you control what you control. You can do your probation order, you can work that program, but you also have to work with your caseworker and the expectation there. And so when I talk to them, I try to have them build the trust, control what your own behavior, do what you have to do, but you have to trust your caseworker, you have to trust the collaboration between them, that the caseworker is working with your family, hopefully to get you in a less restrictive placement or back home. I think, and to be honest, I have sort of mixed feelings about this in terms of, I think it's good for the juveniles to have a better understanding of what's going on the child welfare or the 3A side, but I also get concerned that if they get the message that their parents are not going to do what it takes to get them back home, that they're going to lose some of the motivation with that. But I think the prevailing wisdom is that it's better to have the juveniles have all that information as they go forward. And so when I approach it twofold. You control your life, what you need to do to make it possible so that when your parents have done it, you can get back home. And to do that, you have to trust both systems and that they're working together for you.
Dennis, your thoughts?
Well, it's kind of the same approach that Judge Gendler uses. My analogy with clients, because I want to make sure that they understand the process, and I want to make sure that they understand the roles of people. I use the train track analogy that you've got two different trains running on two different tracks. They typically run at different speeds. They occasionally, the 3A train and the delinquency train, and they occasionally intersect. And they're about different things. And then I always let them know that the standard in juvenile court is best interest of the child, and we all have different roles and different perspectives, including the youth, as to what that might consist of, and talk about that. And when it comes to my role, I typically will end the conversation with the fact that explaining my role as an expressed attorney and making sure that they know that what they think is that what they want to do, whether it's in their best interest or not, is something that I advocate for. Because I get a lot of times, even with the youth that I have a great relationship with, I get the you guys, and it's not that way. It's a we. But I try to let them know that at the end of the day, because I'm their expressed attorney, it makes them my boss, and it's my job to explain options, make sure that they understand options, and try to make sure that when they walk out that door that there are certain things they understand, and the process is one of them. Because it's not the end result where kids or families kind of feel screwed. It's the process. It's what happens along the way that determines the ultimate feeling, the ultimate outcome at the end.
Absolutely. It's that opportunity for the voice to be heard. So, Judge.
I'd just like to piggyback on Marjean's point about these young people are responsible for what they are responsible for, and parents are responsible for what they're responsible for. I think one of the most difficult situations is when you have a young person, maybe when they're in out-of-home care, they're doing their therapy, they're going to drug treatment, they're doing all the things that they need to do, but their parents are not doing that to the same extent. And that's very difficult for these young people to understand. It's kind of like, well, I've made myself better, why can't they make themselves better? And so you've got to keep telling them that this is all you can be responsible for. We're going to make you ready to go home, but I can't tell you your parents are going to be ready at the same time that you're going to be ready. And they may have their own issues that's going to take a longer period of time. To use Dennis's analogy, they're going to be on the track longer, but we've got to keep you focused on you being a healthy guy or healthy young woman. But that's, I think, a very difficult proposition because we often have families and kids progressing at different rates.
Okay, I think I need to bring this to close, and I think we're at our time. I have one last closing question for each of you who you address. You think about those two themes that we've been talking about. One, this notion of having really good information so that we can inform decisions. Again, around charging, around diversion, detention, disposition. That's number one. And then number two, how do we shape our experiences? How do we shape our system so that young people and families experience it in a positive way? You all, in every county that we have had the pleasure of working in, you all have focused on this and introduced great strategies for it. What is, one thing, one additional thing, or an area you think that there's still a little bit more work to be done in your counties, particularly as we think about taking this to the state level? And either one of those themes, the information sharing, the quality of the information, teaming structures that you've got, or this notion of shaping our approaches in a more youth-friendly or family-friendly way.
I know that's a challenging one, and you guys, I didn't prepare you at all for that really challenging question. But any thoughts? Steve, we'll start with you.
So one of the things Maggie and I were talking about on the way here this morning was incentives and some of the challenges that go along with that. So we have, is it gift cards and candy and some stuff I think we've purchased to reward kids for positive behavior. And there are some, some people in the system I think that have the attitude that, these kids should be doing, they shouldn't be rewarded for something they should be doing, and I think there's a lot of us that think the other way, if we can use some of these incentives to really get them to do something and then reward them for what they have done that's very positive. I think that's...
The good news is that you have the research on your side about this notion of catching a young person when they're doing something good, right, and really lifting that up. So that's great. Other thoughts on this from your perspectives, Kara?
I think at this point, at least in my mind, nothing glaring stands out that we're doing really poorly. I think we're doing most things well, but it just continues to evolve and we continue to learn. I think the increasing awareness, just other prosecutors, defense attorneys, people who work in the system who might not know the ins and outs of this process. I think it's good just to increase awareness in that way. Also, just learning from each team meeting, each experience that we have. And we had an issue last night where there were parents, there was a DV issue, they both showed up for the meeting, and it ended up going okay. They were not both in the meeting. But we had to kind of work through it as we went, and then we thought, okay, well, this is something that we're going to talk about at the next work group meeting. So I think just being able to kind of roll with the punches, but take those experiences and kind of officially discuss them to decide maybe how best to proceed next time.
Thank you. Judge?
I guess I'd just go back to that, make sure you're operating according to the integrity of your word. So that people get cynical about the system when things don't happen the way that they've been told it's going to happen. So you can't overpromise, but you can follow through with all the things that you said you're going to do, and that's whether it's the judge, whether it's the probation officer, whether it's the case manager. That integrity of your word is one of the most important pieces in getting cooperation and getting compliance and getting people back to being healthy people.
Great point. Judge Hammond?
Just briefly, trying to alleviate the pressure of the process, just generally on these folks, because I can't imagine, I think it's enormous. And the issue with mental health, which permeates everything, just to make sure that we're sensitive to those issues and we're addressing those issues.
Yeah, Dennis and Margie, to close this out.
Well, I guess if it were up to me, there would be more deference to the public defender's office. So, but on a more serious note, if I had one word, it would be lens. And this may sound pretty simple, but I think when we look at these youth and we look at these cases, we always have to have the lens of adolescent development, and we have to remember these concepts, and we have to develop plans based on that. I think there's sometimes a tendency to project our feelings, our thoughts, our processes, and almost at times treat them like mini adults, and not understand that they think a different way than what we do, and their background may not have been our background growing up. So I think it's putting ourselves in their shoes, and just remembering, we're dealing with teenagers, So anyway, that's my thought.
Margie?
I can hardly remember the topic or your question at this
Any areas
point,
to
but
enhance or improve
in
on?
terms of information sharing or systems changes, I think one thing that Lancaster County needs to do better is, as I listen to some of the other jurisdictions and what they're doing, you've got Douglas County having this meeting before they even decide what you do. I can't remember which county it was, talked about knowing when their detention hearings were and having a meeting before that, or their hearings. We don't have anything like that in Lancaster County. Our detention hearings are set sometimes with an hour notice. So we have no ability to really have these kind of meetings and information sharings before we're going into a detention hearing. Our courts have accommodated it on the child welfare side. They have their temporary custody hearings every Wednesday at 10:30, so that there can be these pre-hearing conferences. We have nothing similar on the detention hearing side. And so I think that while probation and child welfare may share information before you go into these hearings, none of the attorneys have. And so that's part of my response you heard earlier where I say it's not flowing upwards. So we're still having adversary hearings because the county attorney and the public defender, we're doing our discovery. We're learning about these kids. We're learning what the recommendations are during the hearings. And so while I think there is good information sharing going on, I think that's something that Lancaster County probably needs to do better in terms of advancing this project.
So you have really illustrated why we wanted to have this convening, right? Which is really to lift up the innovative practices that are taking place across the state so that you can get ideas to bring to your own counties. So thank you for sharing that, Margie, and I think that was the perfect way to close on that. Please join me in giving these folks a hand. We're going to take a 10-minute break, is that right? Okay.